Okay, so I'll back to the again. I want to approach. Yeah, I want to approach. Because I really just want you say it. And then.
All right. 14A District Court for County of Washington, State of Michigan is now in session. All those having business before the court draw near, the Honorable Judge Jay Secretary to decide.
You may be seated. Okay. Morning, everyone. Court does call the case of Ryan Verrender versus Mary Barney.
Good morning, Your Honor. Shannon Urban, P73873 on behalf of Ryan Barrenter.
Good morning, Your Honor. David on behalf of Mary Barney.
All right. And you folks have a conditional dismissal. Is that what we're doing today?
That's correct, Your Honor.
Yes, Your Honor.
Okay. Okay, very good. Since both sides are represented by counsel, court will sign that. And this case is conditionally dismissed. Thank you.
Thank you, Your Honor. Have a great day.
You do the same. What is this?
Booties.
Court calls the case Avalon Housing versus Yolanda Shepherd.
When someone swears to tell the truth, the whole truth, and nothing but the truth, you can almost feel the irony in the air. Because truth here is never whole. It's cross-examined, dissected, and negotiated until only fragments remain.
Morning, Your Honor. Jillian Engen for plaintiff.
Good morning, Your Honor. Andrew Campbell, on behalf of the defendant. Judge, this is the date and time for a motion hearing. However, I just spoke with opposing counsel, and if you could.
Yeah, Your Honor, I think that we are going to be able to come to an agreement on this one and settle it. Ms. Shepherd was able to get most of her belongings out this past week, and so she's going to be I think that we're going to be able to resolve this one amicably. If we just need a little bit of time. If you wouldn't mind adjourning it. I think we could put it, it's up to you, Your Honor, if you want to put it back on the regular docket or if you want to put it over to the next.
What am I doing with the motion?
Your Honor, I think that if we resolve it, I think that the motion would be withdrawn depending on how that goes. And then we would also have more time to respond, Your Honor.
You agree with putting it back on the Friday docket?
Yes, Your Honor.
How much time do you guys need?
Could we do this Friday? Is that too soon?
I have no problem with this Friday. I have to be here anyway, Judge. Does that give you enough time?
13th.
I think so.
I'll adjourn it to June 13th, 2025 at 12 noon.
All right. Thank you, Your Honor.
Thank you, Your Honor.
Thank you. You're on Vista Apartments versus Shanice Morris.
Jillian Engen for plaintiff, if I can say my own.
How you doing, Your Honor?
Very good. How are you?
Hanging in there.
Okay. All right. What are we doing?
Your Honor, I believe that we're close to a resolution. I think that if we could go into one of the breakout rooms and just kind of hash things out. I think.
All right, I'll pass. You agree with that?
Yes, sir.
All right, very good. I'll let you guys do that. I'll pass that case. Then Sycamore Meadows versus Derek Hall.
Good morning, Your Honor. Attorney Carrie Dan on behalf of plaintiff.
Good morning, Your Honor. Emily Brule, PA8273 for defendant.
Can we approach Judge?
Sure.
Thank you.
Sometimes justice whispers, other times it roars. But the most dangerous sound is laughter, the nervous kind that slips out when people realize they're in deeper trouble than they'll ever admit. In that moment, the courtroom becomes painfully, uncomfortably human.
It should reflect we have a bench conference in this case. We've been back time and time again on this matter. And the last time that we were here, counsel and we all met. I told them how I viewed this particular case and that there was an offer that was made. I assume it was going to be accepted, but maybe it hasn't been.
Just for the record, Judge, I don't have authorization to agree to the terms that opposing counsel has laid out to the court, which is $500 for the balance of what's owed. And he's to pay that, I think, over 5 months, $100 a month to Sycamore Meadows. The only thing that I would ask is that his counter complaint be dismissed.
Anything, Ruby?
No objection. I do want to note that the $100 a month part was not a specific criteria, but $500 over the course of
5 months. Yeah.
So what the court's going to order is, I'm going to do this in the form of a conditional order of dismissal, where the defendant will be paying along those terms of the $500 and the $100 per month. And I will at this time also dismiss the defendant's counterclaims.
Thank you. Thank you.
Thank you. Jeff Lewis versus Jennifer Loudon.
Morning, Your Honor. Daryl
Should have
Bond,
said
appearing on
the more
behalf
important person, Julie Lewis. But go ahead.
of appearing on behalf of Jeff Lewis. This was a show cause hearing.
Yes, a show cause for their failure to appear at the. All right. Defendant having failed to appear. Bench warrant will issue. And what is the total amount of the plaintiff's claim?
Let me look at my notes, Your Honor.
Still the
You have it.
8702. Well, what was the judgment amount? I guess I.
$917 plus the subpoena cost.
Oh, I'm sorry, Your Honor, but I came in late on this case.
Yes, no, that's okay.
It's been a while. There was a default judgment some time ago. And 9,000, the default judgment was $9,819.50.
9,800.
In addition to that, there you have the subpoena fees.
Right. What I will do in this case, also going to be interest, which would accrue on that.
I'm sorry, I didn't hear you.
Pardon?
I didn't hear what you were saying.
I was saying there's also, I mean, at some point there's going to be interest that accrues on it also. So, but a bench warrant will issue, bond will be set in the amount of $10,000 cash. We need identifying information to be able to enter a bench warrant.
That is correct. There should be a form.
Right, that you have to fill out at the clerk's office to issue that bench warrant.
All right.
All right.
Thank you very much.
Thank you, folks.
Oh, I have another question on this case. I knew there was something else.
I told you she's the one that should have come up and not him. But whatever. Go ahead. Yes, you may.
In legal battles, truth isn't found, it's built, layer by layer, like a fragile argument on shifting sand. And when it finally stands, everyone stares, wondering if it'll hold or crumble under the weight of one more objection, Your Honor.
You ready? Court recalls the case of Huron Vista versus Shanice Morris.
Jillian Engen for plaintiff.
Your name,
Your Honor.
all right, where are we on this?
All right, Your Honor, we have a conditional order of dismissal. I can place terms on the record.
Yes, please.
Thank you. So the terms are that defendant may retain possession of the leased premises, provided that she complies with the following provisions. Defendant shall arrange for the arrearage in the amount of $797 to be paid in full by SOS or Hawk on or before June 24th, 2025. Another provision is that defendant shall ensure completion of recertification on or before June 17th, 2025. And then defendant shall arrange for payment of the DTE bill in full on or before June 30th, 2025. Then provided defendant complies with the above provisions, the parties will coordinate a transfer of defendant to a 1-bedroom apartment to start on July 1st, 2025.
Got it.
And I'll get that in writing to Ms. Morris. I have her email address.
Okay.
And
Is that the terms?
Yes, sir, Your Honor.
Okay. Have you been working with Hawk?
SOS, yes.
SOS, so the payment won't be an issue on,
No,
in
sir.
terms, okay, gotcha. Okay. So once that's presented to me, I will sign off on that. And I have to let you know that you have 3 business days from the time of my signing to think about that conditional order dismissal. If you think that there's some confusion, some right you didn't assert, or some other mistake on that, you'd have to file a motion with the court within those 3 business days. You understand that?
Yes, Your Honor.
All right, doesn't mean I grant it, but you'd have those 3 business days to do so.
Okay.
one more thing, Your Honor, I just do want to make it clear on the record that if any of the provisions are not complied with, then plaintiff is entitled to an immediate writ of eviction and judgment for possession only upon a filing of an affidavit of noncompliance with the court without further hearing, but with notice to defendant via mail.
Okay. You understand that?
Your Honor.
All right, fantastic. I will mark that. Thank you folks for working it out. I will mark this file conditionally dismissed and I'll await the order.
Thank you.
Thank you, Your Honor.
Thank you. You guys have a great day.
Have a great day.
You too. So we had one other person come in. Is that with Huron Vista?
Yeah, she's a property manager.
She's proper. Okay. All right. I just didn't see her initially. I didn't see you either.
You're on, that's it, 8 o'clock.
That's it.
Yep.
We're all done
Until 1 o'clock.
till 1 o'clock?
Yep.
Oh. I bet you want me to stand in recess.
I would prefer you do that. Sit on the record for 3 hours.
Court stands in recess.